Last Friday, the Supreme Court ruled that a group of Maryland parents who had sued the school district in Montgomery County do have the right to opt their elementary school age children out of instruction that includes LGBTQ themes. By a vote of 6-3, the Supreme Court justices agreed with parents, which were a coalition of Muslim, Catholic, and Ukrainian Orthodox families who were arguing that Montgomery County School Board's refusal to allow them to opt their children out of this instruction was a violation of their constitutional right to exercise free religion. Fighting for the majority, Justice Samuel Alito wrote that what the parents were seeking here is not the right to micromanage the school curriculum, but rather to have the ability to opt their children out of certain types of instruction that puts a burden on their well-established right to direct the religious instruction and upbringing of their children. Similarly, parents in many school districts have opposed mandatory sex education curriculums as well. Writing a dissenting opinion, which was joined by Justices Elena Kagan and Ketanji Brown Jackson, Justice Sotomayor warned that Friday's decision threatened the very essence of a public education because it, quote, strikes at the core premise of public schools, that children may come together to learn not the teachings of a particular faith, but a range of concepts and views that reflect our entire society. The case came to the court from Montgomery County, Maryland, which is one of the most religiously diverse counties in the entire nation. The dispute started back in 2022 when the school district authorized the use of certain books in the curriculum for elementary school, which included a book called Uncle Bobby's Wedding, which tells the story of a little girl's reaction to her uncle's same-sex wedding, and also a book called Pride Puppy, which talks about a puppy who gets lost at the Pride Parade. The county initially allowed parents to opt out of these books, but in 2023, they changed that and said that nobody could opt out of this curriculum because it was too difficult to manage the opt-outs. Lower court sided with the school district, and it eventually made its way to the Supreme Court, where that ruling was overturned.